Not the first time that the first petitioner is making such allegations about judges. He did so in 2023 about your sister, Lady Justice Esther Maina. In the letter addressed to the Deputy Registrar, and I refer you to paragraph 10, he insinuated, in paragraph 10, he says the lightning speed with which the Kirogoya file was grabbed and directions issued seems like a well-orchestrated plan to trample on the rights of the petitioner. They made allegations against the Deputy Chief Justice. In the same letter, they have asked an investigation be done in which they insinuate the conduct of the Deputy Chief Justice, the Chief Justice, so that, my lords, they have made allegations about 6 judges.
Your Lordship, I'm constrained to interject. My learned friend and my very good friend, Mr. Mushemi, is alluding to going to talk about some grounds which he says were before the Senate, but which were dismissed. So,
no. That is not correct. Ground number 4, to correct my learned friend, was supported by 51 senators out of 67. It was one of the charges that was upheld by the Senate.
My Lord, those are the matters that are in the petition, and that is where we are before you.
Let us restrict ourselves to the application.
Most obliged.
Yes, my lords, the nexus of this application, the nexus of my response, is that the first petitioner has impugned the conduct of 6 judges. This has never happened before in this country, that one person is unhappy about 6 judges. At the same time, my lords, you have been treated this afternoon to issues of bias. The first petitioner had his day before the National Assembly. In that house, 282 members of Parliament voted to impeach him. Out of those 282 members, a majority of them were from his own party, United Democratic Alliance, where he is the deputy party leader. They were not biased against him. The matter went to the Senate. 53 senators, a majority of them from his own party, voted to impeach him. He did not raise the issue of bias. My lords, you have been treated to the issue of weddings. Weddings by the petitioners. I ask this court to take judicial notice that in the National Assembly, and my learned friend Kibe Mungai spoke about our tradition, we come from the same community, the first petitioner last year attended the wedding of a member of parliament, Eric Wamumbi, member of parliament for Madeira, where the first petitioner comes from. That member of parliament subsequently impeached him. If the basis of closeness is the basis of impeachment, how would somebody who have attended his wedding impeach you? But he did not impeach him because of attending his wedding. He impeached him because of serious violations of the Constitution. So that if the issue here is a wedding being attended, the first petitioner himself has attended a wedding, and not just as an ordinary guest. He was the father of that member of parliament in that wedding. But he was still impeached. So that, my lords, I want you to take comfort. Those are matters before the Hansard of the National Assembly, which is evidence before this court. Your lordships should take comfort. The first petitioner in the National Assembly, he impugned institutions, In the Senate, he impugned the Ethics and Anti-Corruption Commission, the National Intelligence Service. He has now impugned the conduct of IEBC. He has now impugned the conduct of the National Assembly. He has impugned the conduct of the Senate. He has impugned the conduct of the executive. So which institution does he have faith in this country? It appears that there is none. My lords, eminent judges, it is a matter of judicial notice that your esteemed colleagues, although the petitioners argue that you are unfit to hear this matter, have elected one of you, presiding judge, to be a principal judge. Your own peers, through a peer review. All judges in the country have elected one of you to be principal judge. Your peers equally have elected one of you to the Judicial Service Commission.
My lords, our application is limited to your lordships and her ladyship, not the other judges. And there are many outstanding judges in this country with courage, with everything. The petitioner has not cast aspersions on judges generally. We've stated our grounds for the application for recusal of this particular bench.
Your Lordship, the character of judges in this session has been impugned by several counsel appearing for their clients, and it is important that we rebut the issue of their character.
Proceed, please.
Thank you. Your Lordships, my client, the 9th respondent, has also filed a public participation report before this court. 200,000 Kenyans exercise their right of public participation in the National Assembly.
What has this got to do with the recusal? That's the only thing we argued, my lords.
If my learned senior would be patient, I'll show him the nexus.
Yes, if you are relevant, admissible submissions in reply to the issue we argued.
Exactly. You want to let him stick to the application, which is recusal.
My lords, I thank my colleagues. The basis of the public participation, and my lords, when you retire, you look at this. 200,000 Kenyans conducted or went through public participation. 65% of them said that the first petitioner should be impeached. That report is in my client's affidavit. And the reason I am saying this, my lord, is that the nexus of this is that the first petitioner has no confidence in all institutions. He has no confidence in 6 judges. He has no confidence in all Kenyans who went through public participation.
Objection.
He has no confidence in anything.
Objection, Your Lordship, Your Lordship. What is being advanced by Melania Senior will be discussed at the merits, including the character and the conduct of public participation. Is it fair for him to go on ad nauseam despite various objections? We strongly object to that line.
I think, my lord, it is relevant if a litigant has cast aspersions against the court. Some of them he even wanted to withdraw. It is only fair, and it is actually relevant, that the court be shown this is a person who picks the candles not just against the court, but against every known agency and institution of the state.
My lord, I was just trying to keep quiet because of this intervention.
Finish. Well,
My lords, I was finishing.
Take time and finish, and please sit down. You'll respond. Finish.
And I have been very kind to my learned colleagues. I did not even apply that their pleadings be struck out, even when they were fatally defective. I have said let them remain on record. We are not impugning them. So I am being very kind to my friends. Finally, your lordships, if you recuse yourselves, you will do a great injustice to the oath of office that you took, the administration of justice, to allow the petitioners to bully you, to forum shop, They have tried to bully the National Assembly, the Senate. Now they are trying to bully the judiciary. Will be a great injustice to this country. That is all, Your Lordships.
Thank you.
The respondents rest there.
Oh, Professor.
Sorry.
Presiding judge and distinguished members of the bench, Mahat Somane for the IEBC. I think everyone is in the arena, the independent body. No one wants it to talk. I think we have something to say about these proceedings. The leadership, the IEBC's position is the Independent Electoral and Boundaries Commission, the 16th respondent in this second cohort. The IEBC's position is that the court should stick to first principles when it is determining the issue of recusal. We have been listening keenly to the submissions by the various parties, and our position is that the court has a three-tier constitutional doctrines that it has to satisfy itself. The first one, when the court is determining the application for recusal, is whether there is reasonable apprehension of bias. The question the court should ask itself is, do the circumstances give rise to a reasonable apprehension in the mind of, number one, a reasonable person, number two, a fair-minded person, and number three, an informed member of the public. So the test is all those three criterion has to be met. The second constitutional criterion that has to be met is the presumption of impartiality of judges pursuant to the oath of office they took must be rebutted, and that with probative evidence, not on aspersions, not on allegations, with probative cogent evidence. The third one, which is also a third constitutional doctrine, is judges generally in our constitutional dispensation have a constitutional duty to sit. We give them security of tenure. We pay them from the consolidated funds. They have a duty to sit and to hear all matters. And that duty can only be rebutted when there are valid grounds relating to it. We refer the court to the authority which has been placed before it, Sholei and another versus Judicial Service Commission, petition number 34 of 2014. We refer the court to paragraph 5 of the said decision as relates to the duty to sit in every matter and not to choose on any allegation that is made on it. We refer the court to paragraph 16 of the said judgment, the very analysis done by Justice Mohammed Ibrahim and the dicta of Lord Denning. We refer the court to paragraph 27 as relates to recusal and reassignment. And if the court applied first principles, the position of the Independent Electoral Commission is the threshold has not been met. The matter should be expeditiously disposed by the court. Thank you.
That is the respondent's case. We have nothing further to submit.
Thank you.
My lady and my lords, on behalf of the Law Society of Kenya, our duty is to set out what the law is in view of the facts that are before the court. The law, insofar as recusal is concerned, can be well traced in Kenya in the decision of Rai Group Limited versus Kimeto and Associates. We have exhibited this decision in the list of authorities filed before the court. Permit me to set out what was reiterated in that decision. The real question is whether reasonable apprehension of bias was presented which would make an informed and fair-minded person seized of all the information surrounding this matter and the impartiality required of judges by their constitutional oath apprehend bias on the part of the bench. Now, what is the information surrounding this matter? Let us start with the case of Honorable Justice Freda Mugambi. The charge in respect of which recusal is sought is that she was an LLM student of Professor Kindiki Kithure. It has been demonstrated by facts which are not in dispute that the Honorable Judge was not an LLM student of Professor Kindiki Kithure in the Moi University or any university, but instead her LLM was obtained from the University of Birmingham. It was as simple as that. Issue number two, that Madam Florence Oluoch was appointed to a board by His Excellency President William Samoei Ruto. What are the facts? Madam Florence Oluoch was appointed to the board by Sultani Tuli. These, my lady and my lords, are the facts upon which information surrounding this matter are to be determined. The next authority which we rely upon is the case of Eli Valley Mines versus Lee. And the principle set out in that case is as follows. In this context, the reasonable person is not someone who is hypersensitive or unduly suspicious, but rather a well-informed, thoughtful observer who understands all the relevant facts and has examined the record and law. Now, insofar as Honorable Justice Freda Mugambi and Honorable Justice Eric Ogola is concerned, has there been demonstration on the basis of a reasonable person who has examined the record and law to demonstrate that there is bias, real or perceived? That is the question that this court must answer. What about Honorable Justice Anthony Murima? The charge is that the Speaker of the Senate, the Right Honorable Amason Kingi, attended his wedding. My lady and my lords, there must be meaning to the term learned friends. There are those who have written, including a writer by the name Jess Brailer, a book titled Lawyers and Other Reptiles. And there are those who have also written, including Feroz Norji, practicing an honorable profession. Indeed, we are learned friends. A judge is first an advocate and second a judge. A judge does not reside in isolation. And if I may just say, for example, I've had a cup of tea with Justice Anthony Murima. I've had a cup of tea with Justice Eric Ogola. I've not been fortunate enough to have a cup of tea with Justice Freda Mugambi. Well, they are my friends. But I appear before these courts, and they rule in favor or against me. It is in that context that we must examine, is the charge against Justice Anthony Murima one based upon information in the mind of a reasonable person who has reviewed the record of the facts and the law. And if your lordships and my lady will return a negative answer so far as these questions are concerned, then you must make a decision whether to recuse yourself or to continue handling this matter. It is my humble submission, based upon what you've said, that there is considerable doubt as to whether a case has been made out to warrant recusal. We request this court to dismiss this application. I'll allow my colleague to utilize the remaining 2 or 4 minutes to say something.
My lords and my ladies, Nishuki for the Law Society.
Was representing the Law Society?
Yes. My lords and my ladies, I will start off by the submission, clarification of the submission that this application for recusal is the court being called to trial. That cannot be further from the truth. An application for recusal is in its very nature a call for the court to introspect. Given that to assume otherwise would be oxymoronic, as the court would be sitting on its own trial, which is what the recusal motion is. My lord, I move on to this duty to sit. That duty is not one that should be carried lightly. That duty flows from Article 159. And the judicial authority that is vested upon you as judges. To not fulfill that duty is to abdicate a constitutional right that you've been granted. Therefore, in making this decision that you're called upon, you must always at the back of your mind have that clear obligation that has been bestowed upon you by the people of Kenya. My lord, we've heard repeatedly from the prosecuting counsels in this issue, and they've referred to perceptions. And it caused me to check what this word perception actually means. Perception flows from a Latin word, which is percipere, which means to seize or to understand. And the dictionary defines this as the way in which something is regarded, understood, or interpreted. That being said, on the facts before you, could they be perceived to put across actual or even apparent bias? That is a question you have to answer. I will discuss briefly what has been said by my colleague, my senior Mr. Somani, on the test that you must apply. That test is an objective test. That is not in question. Therefore, we call it into question the fact that reliance to show the general public perception of this bench was on a tweet by my learned senior counsel Agmenasi. We urge the court not to take that direction, as it would be then turning that test not from an objective test, but subjective test, looked at from the perceptions as they are held by senior counsel Agmenasi. Your Honor, my lords and my ladies, we ask you, please, do not fall into that folly that the applicants seek to drive you. My lord, lastly, I will discuss one of our cases with regards, and this is particularly with regards to the profession, as has been discussed by my seniors, that we are indeed a homogeneous group. We are all advocates, and this is particularly important when it comes to the allegations as against Justice Murima. In the case that we have placed before you of Perry versus Schwarzenegger, it runs from page 62 to 82 of our bundle of authorities, which is duly filed. The court had an opportunity to discuss an issue of recusal that had been lodged as against the judge, simply on the basis that he had a similar characteristic with some of the parties. In this case, the perception of bias is that Justice Murima is friends with His Excellency the Senator, who is a fellow learned friend. And the court said this: in a case that could affect the general public, based on the circumstances or characteristics of various members of that public, the fact that a federal judge happens to share some of the circumstances and characteristics will only be affected in a similar manner because he is a member of the public. This is not a basis for disqualifying a judge. My Lord, having considered the law and the facts before you, it is readily apparent that this application has not risen up to call for your introspection with regards to empanelment in this matter. That is all.
My Lord, allow me to just seek a procedural clarification that the right to reply is available only to the persons who, the advocates who filed the application, and not the parties who supported that application.
We made that clarification at the beginning.
Perhaps, my Lord, you could also confirm whether it is limited to matters of law.
I said that we made that clarification at the beginning of the proceedings.
My Lord, you could also perhaps confirm whether the reply is limited to legal issues, because if it's another bite at the cherry, we will not have the opportunity then to again come back to redo it.
The reply will only be on issues of law and nothing else.
Thank you.
Dr. Kamino, you can say.
May I say what I mean?
Yes.
I don't think, but my point was also, if there is a matter, we're expounding on the law on a matter relating to impeachment of the party. I pray that you allow us to say, you allow me to say something.
I said you can proceed.
Okay, yes. I'll take with that. And God bless you.
Thank you very kindly. I will do part of the reply, then I'll pass over to my senior. And I'm amazed at what level the respondents have gone to misconstrue and misconceive the applicant's case. Your Lordship, in respect to the relationship that were drawn, both for the presiding judge and Justice Murima, the charge is that of deliberate failure to disclose the relationship. That my lords, you are aware at the time of the inception of the case that Justice Murima is closely associated to one of the parties, but he deliberately failed to disclose. Equally well, the presiding judge was well aware at the inception of the case that his spouse is greatly connected to some parties in the proceedings, but again failed to disclose.
My Lord, that is new facts.
I think you should not tell which parties. You say clearly, if you can't understand what we are doing, please go to your affidavit and read the affidavit again.
My Lord,
and reply on matters of law. I will not allow you to misrepresent facts. You have an affidavit.
And to embarrass the legal profession.
Yes,
Your Lordship,
you have an affidavit, Mr. Ndegwa. If you can't understand what we are talking about, verbatim, read verbatim from your affidavit.
Your Lordship, may I draw your attention to paragraph 74 of the judgment, of the ruling in Navini, the judge says that due to the failure to so disclose on the part of the third respondent, it has led to an erosion of the confidence and the applicants have that will be neutral when it comes to the hearing and the determination of the arbitration. That, Your Lordship, is a confidence that has been eroded. On the question, Your Lordship, on the duty to sit, the duty to sit must be accompanied by transparency and accountability to the parties appearing before a judge. Your Lordship, the duty to sit and the oath of office taken by a judge or a judicial officer must be executed in a manner that breeds confidence to the parties that appears before a judicial officer. Your Lordship, it's our humble submissions that confidence has been eroded. Your Lordship, the arguments by Mr. Nyamondi that the parties are forum shopping. Your Lordship, this bench was constituted pursuant to Article 165, Clause 4 of the Constitution, and no petitioner herein has the capacity to direct the Chief Justice who constitutes the bench as to which judge to sit in a particular bench. There is no possibility, Your Lordship, therefore, for an argument that parties are forum shopping. At the inception of the proceedings, Your Lordship, we appeared before you and made arguments comfortably. Little did we know that we would be faced with an application of this nature due to the failure of the honorable judges to disclose those material facts. I invite Kibe to proceed.
My Lord, while during the course of, I guess we've been here for about 5-6 hours when this application has been going on, and there are two things that have been crisscrossing my mind. My Lord, the first issue is the issues of substance and the issue of perception, the optics. What would be the optics, my Lord? The optics, my Lord, as we sit here in public view, in the glare of Kenyans, some of whom, if you use the reasonable test, are professionals, people who have studied above Form 4, probably half the populations. The other half of the population are people who are definitely below Form 4. So what's the reasonable person's test here? And what are they seeing? The first thing, my lords and my ladies, that they are seeing is that the petitioners appear to be categorical for good or bad reasons, that they do not have confidence in the bench. And examinations of the fact may still prove that they may or may not be wrong. But the issue is the test, as far as when you read all these cases, in matters particularly that have some political angles, perceptions is everything. And perception is a big issue. So that, my Lord, the issue therefore would be, shall we proceed on the basis where from the word go, the petitioners clearly have appeared to the rest of the country, they have got no confidence. With the same zeal and spirit, the respondents who are being accused for good or bad reasons are saying, we have full confidence in them. That should trouble us. Because at the end of the day, it is the coloration of whatever decision is made. It will be done from the prisms, oh, we told you, we knew this, they were going to do this or the other one. In huge cases like this, it should never be that way. I go to the second issue, the issue of the Honorable Attorney General. I listened to the Honorable Attorney General. The Honorable Attorney General has made an application, one of the applications to set aside the orders. I went back to Article 156. 156, on one hand, suggests the Attorney General is the President's lawyer. There is another clause, I don't know whether it's 11 or something like that. It suggests that the Attorney General is the guardian of public interest. And you ask yourself, the Attorney General, without doubt, when it becomes to the President, he's 100% sycophantic, a President's lawyer.
But my Lord, when it comes, raising a new issue, that
which
is
the
never
new issue,
part of the recusal application.
That is not a new issue, my Lord. Let me proceed. My Lord, the Attorney General is the guardian of public interest. What is the public interest in a process of impeachment as we stand here today? My Lord, that public interest must be the country has been treated with an imperfect, I'll not go to the details, with an imperfect impeachment process at the National Assembly and at the Senate. When it reaches towards the tail end of this process, the public will be treated to the fact that in processes that presupposed that you would take about 75 to 100 days were conducted within hours. So that the bigger questions, my Lord, would be that there is a complaint that is being made, a serious one, of the right to fair hearing and human dignity. Rights that are not derogatable under the Kenyan Constitution, even during an emergency. My Lord, if you are faced by an Attorney General who, pursuant to one mandate, their conscience has not been touched, that there is some public interest in looking at these things a little bit from the perspective of the Deputy President, and those who feel like the Deputy President, that a fair and square deal has not been granted by the processes that have taken place. Your Lordships, that should concern us. I go to the next issue, the main issue that he cannot deny, he did say. My Lord, you are being told that we are in serious danger, we are in the throes of chaos or something like that, and there is some danger. My Lord, the truth of the matter is, the time that has been prescribed, thank God, by the Constitution itself, they are far from over. And the petitioners here keep saying, and Honorable Mwite has told me, tell the court that if the court can be able to hear us from next Thursday when all of us have done responses and whatever amendment, we are ready to conclude that issue. We are ready, we know the timelines. So that, my lady, the connection, therefore, of somebody saying that, oh, the only public interest here, and this is the Attorney General, is that we must swear by hook or crook before the petition has been heard, that also should be a matter of grave concern.
Sure, because there was never a submission like that, and I think Council must have some respect for the truth. Nobody said anybody must be sworn by hook or crook. Please let's respect the truth.
My Lord, I think the language always in submissions belongs to Council, but what Professor Gedhu Muigai, my former teacher, said is this, that we are in the throes of instability, something to that effect, because if we do not complete the process that was started by the National Assembly, a huge power vacuum might arise. And that it is why, when I use hook or crook, it is why the only obsession that we hear, it's conservatory order taking out. That is the context. My Lord, I go to the next issue. Who is this who made the oath of office of Professor Ojenda? My Lord, there was the question of CTS. The question of CTS, I believe, had dealt with it, and all those kind of issues, and we pointed out that the issues of CTS, whereas we had talked about them, they appeared for the first time not from the respondent's affidavit, but from the ruling that the court made. I don't need to say anything about it.
the respondents had said nothing about them. My Lord, to Professor Ojienda, there is a question of... no, I have to respond. There is a question of the internal memo. The question of the internal memo, again, that was not a matter that was ever placed here in any affidavit, as far as I'm concerned.
That was yesterday's submissions. I think you were here.
I think these are notes for today.
Those are notes for yesterday.
No, these are notes for today, my lord.
That was yesterday.
No, my lord. If they have a date and I had a different notebook, but they would get uncomfortable. Let me pass that. In fact, he's not the main guy I have to deal with. About all these issues, he talked about the internal memo. But well, if he says he didn't, let me hope I imagined it. I can pass it. But that's what my note says. I don't mind. We can't fight over a memo, and as I said, we are dealing with some other submissions. My lord, My lord, there is a question of Mr. Nyamodi. Mr. Nyamodi was talking about the issue of the...
My lord, this time is up. Just sit down.
He was trained by Kithure.
Just to confirm, we have not touched his notes.
Allow me to remind him what I said.
No, the only misplacement was this guy.
My lord, maybe we should correct that as well, because it's been said 3 times. There are no guys in court. They are learned counsel.
My learned colleague, professor, is the only issue, the reference, senior counsel. Is that doubted? My lord, the issue that would require the clarification, let's go to Kerogoya. I believe there is no doubt about the issue of Kerogoya. My lord, the issue that was raised, and I believe this is the last point that Professor Muigai was making, regarded the issue of where it was alleged that the issue estoppel with regard to the issues of Kerogoya that found themselves in the ruling of yesterday. And my lord, first of all, I wish to point out that there is a notice of appeal that is one of the annexures in the supplementary affidavit and raises specific issues about preempting and the issues dealing with matters that were yet to be handled. I need to clarify that is one of the issues when it talks about the issues of res judicata. And when it comes also to the issues of res judicata, it is important, my lord, that it is pointed out what was the subject matter of yesterday's application. It was the interpretation and application of Article 165(4) of the Constitution in relations to the powers of the Deputy Chief Justice. The said ruling, anything else that may have been said that was outside that is direct issue that was before the court, that was not an issue for that ruling. And therefore, dealing with matters that are outside there and you are be told the ruling has dealt with those matters, which it ought not to have dealt with, so it has become res judicata. It cannot become res judicata in our submission. My Lord, with regard to the issue of the friendships, I think this is something that they have been preoccupied with. My Lord, nobody is trying to criminalize friendships, not at all. But my Lord, there are always degrees of friendships. When it is alleged, for example, that a friendships between Kibe and Ndegwa is of such a close proximity that Kibe and Ndegwa ought to disclose that fact to any other person, it would be different, for example, to my friendships with Harvey, somebody we just meet and do a few cases with. So that, my Lord, the issue at the end of the day is one of degree. To what extent are there interactions between these two individuals? Because, my Lord, and we were saying that you may feel that there are issues. Issues could well be raised. That who was so that, for example, was Judge Mrima from the Kenya Law Reports records, as people would be sending materials to indicate that, the lawyer for Mheshimiwa Kingi during the case with Esposito? Again, the answer would be yes. So this is not a casual friendship. It is a friendship that is over. There have been had client-lawyer relationship, other personal relationships are all there. So that, my Lord, you cannot be able.
Now, how do we respond to that?
Mr. Kibe.
Yes, my Lord.
I had intended to restrain myself.
Yes, my Lord.
From interjecting in these applications. But I think the statement you're making is factually incorrect. In the Esposito matter, I appeared as the advocate for IEBC, yes, not Mr. King.
Yes. Thanks for the clarification. My Lord, the issue...
I think if we people can respond on issues of law, it would really help us, rather than going back on issues of facts.
Yes, so that, my Lord, there was the questions of forum shopping. Forum shopping, I go with what Mr. Ndegwa has said. If this bench recuses itself, it does not mean that we shall choose any of the judges that may replace this bench. My Lords, on the issue of Mr. Mushemi's submissions, my Lord, Mr. Mushemi's submissions, we start first of all from the premise that Mr. Mushemi did not have a replying affidavit. We did not have a replying affidavit. I tried to object. In order, you said I respond. We want just to draw the court's attention that if you want to take factual deposition, you take somebody else's affidavit that has been deposed to on oath and say, this is not true, you did not sign here, you did not do this, you have not subjected it to any examination or anything, that would be completely to go outside the rules of evidence as we understand them. And therefore, for as much as the issues of Mr. Mushemi is concerned, I urge this court to disregard them. There are two other more important issues that we need to point out. My Lord, using the test of the reasonable man and woman in Kenya, it is a question of splitting hair. President Ruto and Tuya. Is splitting of hair for the simple reason that during even the Senate proceedings themselves, we were treated to a situations in which, and one of the principals was indicted, in which political positions at cabinet, board levels, and others were toss-ups for purposes of political dealings. The average knowledge, because that is the standard that you've said, a reasonably informed Kenyans is aware that any new government comes to office with its own appointees to those board positions, permanent secretaries, and others.
Mr. Kibe, you are going beyond what is really necessary for this. I think you have made your submissions. Respect the court. and your colleagues reply on issues of law, please.
I thought that was an issue of law. My Lord, I finish with the question that was raised by the one without an affidavit by Michael Moshemi. The issue of Mr. Michael Moshemi, where you are told that for purposes of gauging bias, you should be able to look at the MP for Madeira, who did not, who voted against the deputy president, although he was his father or something in the wedding. My Lord, the direct reference to that would also have to be taken from the bar, the way it was also made from the bar, and the direct reference to that is that the wife of this MP...
My Lord, that's a question of fact.
Yes, it was also the same question of fact.
They didn't reply to the point of law, my Lord.
We should understand what we mean by matters of fact. Questions of when, who, where, what happened, who did this, who did that. Those are all matters of fact.
My Lord, the only exception, and we said, when we tried to stop, to stand to say that Moshemi is dealing with those issues, you told me, my Lord, you will respond. So I asked that I respond to that issue. That's the last issue. And the response is this, that the wife of that Madeira MP is also on record as having said that I voted against the DP Gachagua because he insulted us and said our wedding will not last. It had nothing to do with impeachment trials. So that we cannot ignore that is what he said, and it is on public record. So that, my Lord, the long and short of it, so that, my Lord, the long and short of it,
Mr. Kithure,
yes.
How do I record that?
No, my Lord, the way you recorded, I think I saw a record from the other side.
What you are saying?
Yes.
How do I record it?
Well, I don't know who recorded, but he was allowed to say in open court that even his own MP voted against him. So to be able to demonstrate whatever point he was making. And I'm also saying that from the bar, let it also be made clear that the wife to the she's also an honorable MP, said, I voted because the DP said that that marriage was not going to last. Not on impeachment. So that, my Lord, the long and short of it, because we've had a long evening, is that I beseech this...
I suppose the marriage still subsists, right?
It still subsists. and we also hope, my Lord, that when we are that when we are hard with this petition, the tenure of the DP could proceed. So that, my Lord, the last point that we need to make is that there is somebody, I guess, who is a doctor, and something that Dr. Camino has said, a moment of introspection. This moment of introspection is important. Because for you, my Lord, the issue at the end of the day would remain that an important case is up for determination. Besides the information that is here, if your councils were to show what is it that other things that are coming up in the course of the proceedings, that questions of perception is such a huge issue, my Lord, that if you are to apply the old rule that you are being told to apply, that you have a duty to sit, anybody who does not come with a smoking gun, disregard it and sit nevertheless. My Lord, that would defeat the meaning of let justice be done and be seen to be done. But more importantly, it would also affect my reading of chapter 6, the one that would be said that if there is somebody questioning, like the DP, he has written a complaint, it may be right, it may not be right. And it may be upheld, it might not be upheld. But my Lord, the question is, as we await for that day, should any appeal or anything that results from this case relates to the issue that related to the conduct of the judges, or we deal with the issue of the moment. My Lord, with those submissions, I urge you respectfully, weighty as an enormity of having to argue this application, hold as we have tried to convince you. There are more than reasonable grounds that in existence, that there would be something wrong if one were to say, I will disregard all these issues or technicalities and proceed anyway. I thank you very much, Your Lordships. Evans, oh, sorry. My Lord, Evans, there is an authority. I've been under a lot of pressure that he needed to say something about it. And it's part of me.
What will be, how will others respond to the authority?
No, he's answering the authorities that were used, cited.
My Lord, just note that he has no right of reply.
No, I'm leaving.
We're in the same team.
In the same team.
My good friend, Mr. Wanyama.
Yes, he's actually filed the application, not me.
Thank you to the court. I am fully aware of the long day that it has been, and we don't take it for granted. Thank you very much. I want to respond to the following issues of law. Reference was made to the other side, attaching affidavits to lawyers on this side. Affidavits belong to the deponents, the Statutory Oaths and Declarations Act. Conservatory orders are constitutional orders. They are aimed at protecting the substratum of the case. It cannot be weaponized against this side. Third, the diary case. What should concern this court is the pertinent fact and the act that recusal happened, and what the Supreme Court said about that recusal. That's all what this court is supposed to consider. My good friend, my senior, Mr. Nyamodi, urged the court to ignore certain electronic material that was presented for the lack of a certificate as required by Section 106. I'll urge the court to take cognizance, number one, of the short timelines, the reflex within which advocates were required to make the returns. In any case, we will endeavor to file the certificate. In any case, I want this court to be persuaded by the decision in BBI that formal rigidities should not supervene, especially in a constitutional context, bearing in mind the exigencies and the demand. Because under the Mutunga rules, we can even submit here on non-epistolary basis. Finally, and as I sit to this good court, and we respect each and every of the judges and our colleagues on the other side, 4 things belong to a judge: listen courteously, answer wisely, consider soberly, and decide impartially. Those are the words of Socrates. Thank you, Your Ladyship, Your Lordships.
Are you withdrawing the application?
I think we've come to the end of our proceedings today. We will deliver a ruling tomorrow. Dr. Kamuna, the problem is I don't know whether you are talking as a respondent because you had spoken earlier. Is there something else you want to add?
The matter we're dealing with is under Article 145 and Article 150 of the Constitution. We need to approach this matter very closely, not to be tied by rules of practice, theocracy, or what I call it. We are dealing with a delicate matter that is the security of the country
And if I may say so, I'm going to say so, Your Honor, with tremendous respect. You need the best legal minds and the best experienced people to address your issues. It would be wrong to stop you from addressing your issues. It's a fact that we are having a much impeachment.
Proceed.
Oh, thank you very much. Thank you very much. Thank you very much. My Lord, my own, that you are still most of the whole thing. I people to say that. We respect our judges. I respect our judges. I have been very privileged in my entire life. I've spent it saying, may it please Your Honor, may it please Your Lordship. I've interacted with the judges, both at my home, eating with them. They have invited me to their homes and so on. And I had the privilege of working as a judicial officer, as a resident magistrate in the colonial days. And I had the privilege, rare privilege, of even marrying from judiciary. People serving as a judicial officer are decent people. We may have some isolated cases of some people who are not what we think they should be. But the people on the whole serving the judiciary are decent people. And as a matter of fact, I've said it elsewhere, very loudly too. Kenya is what it is now because of the judiciary. Without the judiciary, you would have something quite different in the country. Judiciary has saved the Kenya, has built the Kenya. We enjoy respect that we enjoy in this country because of, or in the world, because of our judiciary. Our legal authorities, by our judges and so on, are cited everywhere now, including ICJ and so on. They are cited with approval, that they are good law and so on. We respect our judiciary. But my lords and my ladies, if you look at Article 145, when you're considering Article 145 and Article 150, we have to be extremely careful. We have to be extremely careful. This is a matter touching on security of the country. And we cannot afford just to stick to certain procedural things or certain evidential things and so on. The court is called upon to look at things very broadly, very, very broadly. What we are saying to your Lordship and my lady, very, very respectful, is that so far as I'm concerned, there's nothing wrong with you at all. But there is a significant portion of the Kenyan population who believe that you are not, with respect to the right people to sit and face a case. And I'm saying to you very respectfully, there's nothing wrong. Give us a good opinion, a good judgment on what you are respecting to you, and you get out of this case. We do not want protests in the streets. People come to the streets and say, oh, the judges who are biased, the judges who are biased. We do not want that kind of thing. Some of us are too old to leave this country to go to Uganda, or to go to Zanzibar and what and so on, to stay there. We want to stay here and die here. I have gone through an experience which a number of you have not seen at all. When Amin came into power in Uganda, in Kampala, I saw things that were not, which were not acceptable. And I'm saying that, look, let us try as much as possible.
But Lord, at those points of law, I mean,
may I say something? With respect to
Dr. Kamuna, we will consider what you have said. I think you have submitted, and we have understood you. You have understood your submission. If you want 2 or 3 minutes to summarize, please do that.
You always save me my and also, the professor talked about law. Let me now give him law, which I don't think he knows. My lords and my ladies, I'm asking you to apply a precautionary principle. A precautionary principle is a principle of environmental law. But this principle has now been translated. It is used in matters of security. On our part, we invaded Somalia when Kibaki was in power because of this precautionary principle. And I'm inviting you very respectfully that you apply that principle, a precautionary principle, when considering the matter under the Article 145 and Article 150. Under Article 145 and Article 150, having in mind the security of the country, so that we do not have protests in the streets of Nairobi, which will destabilize the country and which will put all of us in an embarrassing position. Your Honor, with respect, I'm asking you again, apply that precautionary principle. And when we ask you to get out of this case, we are applying that precautionary principle that we do not want certain evil people in the streets of Nairobi shouting, Hatujapata justice.
That is a threat.
Thank you very much.
That is a threat.
That's what?
It's a threat. Don't threaten us.
What precautionary principle is not a threat?
My lord. Yes.
I would have liked to go on further.
No, please sit down.
And may I say with tremendous respect. My lord, may I say with tremendous respect. I'm very well read. Thank you.
My lords, your leadership, there's one urgent issue that I would like to draw the attention of this honorable court to before the court rises. My lord, in petition 565, there were conservatory orders granted by your brother, Mr. Justice Chacha Moita, on the 18th of October. But they expire today at midnight. My lords, the purpose of the conservatory orders were to preserve the purpose of the conservatory orders were to preserve May I continue, my lord? The conservatory orders preserve the substratum of the petition and the interlocutory orders application in order for the court to have time to consider
Yes, please.
My lord,
you're listening.
I was waiting for my lord Murima, not Mulema, to preserve the substratum, to accord the court time to hear submissions on the weighty issues of law of the Constitution. So my plea is that you extend those orders because they were to expire tonight.
Any response? No. Can we get one response only? Just one response.
My Lord, very briefly. In relation to the question of the conservatory orders, the court will remember that we also filed an application under certificate of urgency on the question of conservatory orders. If at all it is now their changed position that the issue as to whether they can be extended or not should be brought before the bench, we are willing, ready, and able to argue it right now.
Hello, these are orders that have been granted They were in force. There is nothing to argue. We have not come to the applications. In fact, there are another 2 applications for conservatory orders. And I assume that the application by the Attorney General, the Senate, and by the National Assembly for the discharge of the conservatory orders, you'll be here together with these other 2 applications.
No.
I am addressing the court, not the bar.
My lords, if this court is bad for something, it is bad for everything. Until you have ruled on your own suitability to hear the matter, you cannot address any substance.
You are right, Professor Kithure. We meet you tomorrow at 1 p.m. for the ruling.
Thank you. They done their own work.